I want to welcome our viewers from across the United States and around the world. My name's Alan Edmunds, and I'm an attorney that practices national security clearances. Our practice has offices from coast to coast in the United States, and our clients span the globe. We represent active duty military, we represent contractors deployed to Afghanistan and Iraq, and we represent DoD federal employees. I get hundreds of emails each week, and this series of videos is an attempt to answer some of your questions. But I hope that you'll contact me directly at your convenience at 800-481-2526. And the website that you can use is nationalsecurityclearances.com. On that website you'll find a great deal of useful information, some fascinating case reviews of cases that I actually tried in court. And you can look for cases that are similar to yours and answer some of your questions. My phone call is an important one for many people. I only ask that you write your questions down so that I can be efficient. Today I want to talk about a guideline that many of you have called me about. And right now I'm holding in my hands the directive, the new directive, Department of Defense directive. It's called 5220.6. And for many of you that are not attorneys, and some attorneys that don't know this, this has been modified. And the new directive is dated June 8, 2017. Many people are using the old directive. And that's an incredible statement to make, but there's a new directive, and I'm holding it in my hand. Today I want to talk to you, however, to answer your questions about Guideline H, which is drug involvement and substance abuse. I get a lot of calls about marijuana use in high school and college, and people are absolutely amazed that the Department of Defense will issue you an SOR, which is a statement of reasons, informing you that they have initially denied your application for a clearance because of prior drug use. And the prior drug use that they're talking about may go back 5, 10, 15, or 20 years. And what the government attempts to do is connect the dots in your life of instances where you abused marijuana, prescription drugs, or alcohol, to then present to the judge a picture of you that you are an abuser of controlled substances and alcohol and have been for many years. I enjoy taking these cases into court. They are absolutely winnable, but it does count on good preparation. Our office is known globally for the type of preparation that we do on these cases and the manner in which we prepare our clients. We prepare you for court. People leave the courtroom and they say, I could never have done this without you. And their comments are quoted on the website. And I am grateful when I receive those comments because I enjoy winning, but I also enjoy saving jobs and careers. It really upsets me that often I see the government filing charges that I think are insignificant and inadvertent and innocent, and yet what's on the line is your job. What's on the line is your career. Or what's on the line is your mortgage, your house payments, your bills. Everything's on the line, and you are risking your job because of this frivolous complaint. Now that's not to say that the government doesn't bring forth some valid complaints. They do. And not everybody in the United States is entitled to a clearance. But I'll tell you what, and I say this to the judges, everybody in the United States is entitled to a fair hearing before a judge that is neutral and will treat you with respect and dignity. Back to Guideline H. So what happens in this guideline is that many of you are amazed that you're being called to answer or respond to an allegation of drug use that was 10 or 15 years ago. First of all, that is very common. So you're not being picked on. Secondly, you can rebut that allegation with simple proof and evidence of mitigation. I also see a lot of cases where brilliant college students have used Adderall or some other prescription drug in a manner that it wasn't intended. They use these drugs to study, they use these drugs to stay awake, and the government will file a statement of reasons against you if they learn either from your SF-86 answers or a polygraph that you have used someone else's Adderall while you were in college trying to get through an exam. The good news is that I have won several of these cases and they're posted on my website. And the good news is that through good preparation, you can level the playing field so that you have a chance to secure your clearance. As many of you know, if you lose at these hearings, you've lost the opportunity to pursue your career. I have some clients that have a bachelor's degree from a school like Carnegie Mellon, followed by a master's degree in computer science, and then they fill out the SF-86 and they put down infrequent experimental use of marijuana in college, and the government issues them a denial of their clearance. And they have no place to turn. They've studied so hard and they have to respond strongly to secure their clearance. And that's where I come in. I hope you'll call me. 800-481-2526. I love going to court. I love helping you. And I have saved careers for over 40 years. Thank you.